name is Moore. Come on up. That's a cute baby. Oh, Lord. And now we have a case that's 1,300 days old. Miss Moore, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. Hold on a second. Have we done PC on this case? I think we have.
Check the notes, Your Honor. I don't have anything in the notes regarding.
Let's do it real quick. You have charged with assault. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Yes, Judge. On April 10th, 2021, officers were dispatched to an assault that just occurred. Upon arriving, the officer spoke with a witness who had video footage of the incident. In the video, the defendant and the complainant were arguing, and the defendant can be seen spitting in the complainant's face. The defendant then slaps the complaining witness, and the complainant hits the defendant back in an attempt to defend herself.
Who's the complaining witness?
Any witness is
Have any with the relationship?
a neighbor.
Ms. Moore, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. Do you understand? Okay. What do you do for a living, ma'am? What do you do for a living?
I'm a stay-at-home mom right now.
Okay. I'll appoint your lawyer today. Do not go anywhere. Your case is 1,300 days old and it's time to do something. So I'm going to have you talk to a lawyer today. We can just have you wait there. If the baby gets loud, please take her outside, but we'll have you talk with the lawyer today. Okay. Okay. I don't know about signing a receipt yet because it's 1,300 days old, you know, so if we just reach out to the MAC, please. All right, ma'am, please. If you can file no contact and no weapons for now.
Mr. Osborne, I had a PCI agreement worked out back in February. He is a high school student. The phone number I had for him got disconnected. I couldn't reach him, which is why he ended up forfeited. I guess they picked him up where he lives now with his mother in Gregg County. He's a high school student. I'm just saying, like,
You have taken off on me 3 different times, Mr. Osborne. If you think that we are going to give you a PR bond, you are charged with assault, bodily injury. You're facing a year in jail. You had an offer in this case where they were going to dismiss this case, and you have repeatedly taken off, not once, not twice, but thrice. I am not going to give you a PR bond, and we are taking you into custody now. Your bond is now set at $10,003 because of all the times that you have taken off. And I get that you're in high school, but the problem is that you have already taken off 3 times. If I let you go now, what does that tell you? What? It tells you that it's okay for you to do what you're doing and not to hold you accountable. And that's not what we do here. You need to understand that courts are here for a reason. We do court orders for a reason. And when you fail to comply, when you fail to show, there are real world consequences. And I don't know if you have anyone that's going to bond you out. If not, you will be stuck like Chuck with me until this thing is over. And I'm going to tell you now, I'm not into this pleading guilty, time served just to get out, just to ruin your life. I'm not going to let you do that.
we accepted the PCI. The states said they would still accept the PCI.
I get it, but I'm not letting him out.
I
mean, it's 3 times the case. How old is this case? It's a year old, and
you set your bond at 10,000, so you post 1,000 worth of bond.
well, I don't know, because whatever they're going to charge you, I don't know. You're a flight risk. They may charge you more.
Can I ask a question?
Sure.
I don't recall leaving 3 times.
You have a criminal case. You know that you are supposed to keep up with it. There's no out of sight, out of mind. You should have enough wherewithal to say, you know what? I haven't had court.
Oh, you don't do it for yourself, yourself. This ain't the place where you ask questions, okay? All right.
You should have enough wherewithal to know, you know what? I have court and I haven't heard in a long time. What's going on? The only reason you are here now is because what happened?
Bonding company's attempting to get the case reinstated and or a new bond set for them. That's it. We wanted to let the court know it was our fault for not notifying him of
I'm
the
not
May
going to
setting.
all of the sword. It's not your
I
fault.
do understand. Yes.
You know, if it was one time, okay, but we have 3 different times. It's unacceptable. Okay,
If I may,
sure.
he did miss court 3 times, but he missed the first one because I couldn't reach him because the phone number I had was disconnected. I reset it 2 more times to try to get in contact with him. So he didn't purposely miss 3 court dates, is because I couldn't, the phone number I had for him.
He
wasn't-
knows he has court, Mr. Schofield.
I understand.
You know,
I'm just-
Behavior has consequences. And now you're going to see that there are serious consequences to it. He goes with you. Guys. I'm not out for blood, but I want him to understand that we mean business. If he is unable to make a bond by tomorrow, then we can talk, and I'm happy to entertain perhaps something tomorrow. I get it that he's in high school, but I want him to understand that we mean business. And if I just let him go now, it's enabling him, and it's not a good thing. But I'm happy perhaps tomorrow, if he's unable to make bond, we can talk about a PR bond tomorrow.
Should we just set him for review for?
He's
tomorrow?
going to come back tomorrow regardless because they auto-populate.
Okay.
Because that's what happens when we take someone into custody, they auto-populate for the next day. So we can talk about it tomorrow about,
Okay, that's fine. I got it.
because I'm not going to let him plead guilty just to get out and just to get a conviction on his record. And I'm happy to do this, but I want him to understand that we mean business and we're not playing to games. So if he's still here tomorrow, we can talk about doing a PR bond and we'll let him try that. But I'm going to tell you now, he gets an ankle monitor, curfew, and I'm going to drug test him. And I'm going to be his dad. That's it. Okay. You know, Mr. Akers, I was going to give you the benefit of the doubt as far as meth. Shh. Hey, we need to talk. As far as meth, cocaine, amphetamines, ecstasy, THC, I was going to give you the benefit of the doubt on all that. Because I know, because you tested positive just a couple of days ago, that you were probably going to test positive today again. But alcohol is a different story. That doesn't stay in your system 2 days, 3 days. No. And I'm going to tell you now, Mr. Akers, the days of catch and release, done. Guess what happens now?
Thank you, Your Honor.
So I think that at this stage in the game, because we've had so many issues with Mr. Akers, I think probably a TRAS is what we need to do to figure out how we go forward here.
Yes, sir.
But I think that I'm going to do, Mr. Akers, I'm going to do everything in my power to help you. I know that you're not going to like it, and I know that you're going to go kicking and screaming, but I'm going to tell you now, that's it. It's done. And I'm not going to take anything because I want you to get the help that you need. You understand? Okay, goes with you.
And now also,
There's nothing, no justification you can get.